Okay, I hope you can hear me. Welcome everyone to the first masterclass of the Venezuelan Arbitration Association, and to Professor Bourne for accepting our invitation. It is an honor for all the members of our association to have you here today. We are pleased to have an audience connecting from more than 50 countries, including all continents. Many thanks for your support. As I am sure you will understand, we cannot miss this opportunity to introduce AVA, as we call our association, and to make three special invitations to all of you. AVA was born in 2013 in Caracas, Venezuela. Since then, AVA has organized a large number of events in Venezuela for the promotion of arbitration as an effective way of dispute resolution. We have already hosted 6 annual congresses with more than 300 attendees and 25 speakers, including many foreign friends, each year. This year, with the eruption of technology, we celebrated the first Caracas Arbitration Week, which included 2 days of our traditional annual Congress, 2 other events organized jointly with the Venezuelan Association of Administrative Law and the Venezuelan chapter of the Spanish Arbitration Club, Club Español del Arbitraje, and our General Assembly during the last day of that successful and unforgettable week. Among our activities, apart from the annual Congress, we also organized a conference with one of the most prestigious entities for Venezuelan academics, the Venezuelan Academy of Political and Social Sciences, which this year will reach its 7th edition. For this conference, we publish a call for speakers who would be able to participate in a contest to obtain a nomination by AVA to be one of the 2 speakers who will join 2 members of the Academy in a day with 4 lectures about arbitration. This year, we are about to publish the call for speakers, and I would like to invite you all to submit your proposals. This is our first invitation today. We are also in the middle of the evaluation of the papers submitted for the first number of the Venezuelan Yearbook on National and International Arbitration that we hope will be published by the end of this year. Of course, there will be a new call for papers next year, and we hope that the participation grows exponentially. You are all invited to participate. Language is not a barrier, since we also accept papers in English. This will be our second invitation today. And my third and final invitation is for you all to become members of AVA, We have many projects to develop and are open to new ideas. After I have taken some minutes to introduce AVA, it is time to start this first masterclass with our guest of honor, Professor Gary Bourne. I cannot read a full profile of Professor Bourne because it will take a long time, and I have already taken a few minutes. So I have summarized his profile to highlight some of the most impressive professional achievements. Gary Bourne obtained his JD from University of Pennsylvania Law School with a summa cum laude mention. He is an honorary professor of law at the University of St. Gallen, Switzerland, and Tsinghua University in Beijing, and has taught in many of the most relevant universities across Europe, Asia, and North America, such as Harvard, Pennsylvania, Stanford, Georgetown, National University of Singapore, Peking University, University of Virginia, University College London, and the University of Arizona. Professor Bourne is the author of International Commercial Arbitration, which third edition is to be published this year, International Arbitration Law and Practice, and a number of other notable works. He is the chair of the International Arbitration Practice Group at Wilmer, Cutler, Pickering, Hale and Dorr, LLP, and also is the acting president of the Singapore International Arbitration Center, SIAC, Court of Arbitration. Professor Bourne has served as counsel in more than 675 international arbitrations and has sat as arbitrator in more than 250 institutional and ad hoc arbitrations. Gary Bourne has received many awards by the most recognized legal directories in the world. Professor Bourne will deliver a lecture entitled Is Summer Coming? Developments in International Arbitration. Please remember to keep your cameras and microphones turned off, and feel free to post your questions in the chat so we can read them to Professor Bourne at the end of his lecture. Welcome, Professor Bourne, and many thanks for accepting our invitation. The floor is yours.
Thank you so much, Jose Gregorio, for that very gracious introduction. And thank you also to the Association of Venezuelan Arbitration for the invitation to speak this afternoon, this morning, or this evening, as the case may be. Perhaps most importantly, of course, though, thank you to all of the attendees, the participants for listening. My topic today, and I aim to speak for 20-25 minutes or so, is about international arbitration, about its history, and more importantly, about its future. The topic is, with a little bit of tongue-in-cheek, a little bit of a play on prior titles in the field, is summer coming? Is summer coming for international arbitration? In some ways, one might say that summer finally arrived for international arbitration in the last decades, in the last 3 or 4 decades. Of course, international arbitration, the arbitration that we know, had a long lead up to the last 3 or 4 decades. If one digs back in archaeological history, one finds evidence of arbitration, indeed international arbitration, commercial arbitration, being used as long as 4,000 years ago. Cuneiform tablets contain arbitral awards as well as other historical records. The ancient Greeks, the ancient Romans used arbitration, indeed international arbitration, to resolve disputes between city-states. They included arbitration clauses in their treaties between Athens and Corinth, for example. And they also used arbitration, again, international arbitration, to resolve commercial disputes between ordinary business people. Arbitration continued to be used In the Middle Ages in Europe, the trade fairs were known for the use of arbitration to resolve disputes between merchants. Lex Mercatoria, international law of private commercial transactions, was combined with arbitration to give business people a means of quickly and efficiently resolving their disputes. International arbitration was not only a preserve of the European countries that I've mentioned, but was used more widely throughout the world. In India, prior to the colonial era, and afterwards in China, in Latin America itself, arbitration was used both in traditional societies to resolve both domestic disputes, criminal disputes, commercial disputes, but also disputes between different countries. Not too far south of Venezuela, Paraguay owes its territorial boundaries and indeed its independence to an arbitral award. Latin America was in some ways at the forefront of international arbitration in the pre-20th century era. But it was the 20th century era in which international arbitration really came into its own. It was really in the 20th century that the springtime for international arbitration broke out in full force. The starting point in many ways for the spring of international arbitration was the New York Convention, the United Nations Convention on the Recognition and Enforcement of Foreign Arbitral Awards. That convention, which today has 165 contracting parties, is essentially a global constitution for both international arbitration, but also a means of efficiently enforcing international arbitration agreements in Article 2 and international arbitral awards in Articles 3, 4, and 5. Many of the 165 contracting states to the New York Convention have also implemented that treaty faithfully in a number of instances, more than 100 at last count, by adopting some version of the UNCITRAL model law on international commercial arbitration, which gave effect to the convention's basic requirements to recognize international arbitration agreements and enforce international arbitral awards, but also provided a framework by which international arbitral proceedings could be conducted efficiently. Tribunals could be constituted, the arbitral process could go forward, the annulment of awards would be strictly limited to exceptional cases. Nations around the world didn't just sign up to the New York Convention and didn't just adopt the UNCITRAL model law. Their judiciaries also gave powerful effect, robust effect to the terms of the New York Convention and the model law. Private industry, both arbitral institutions and much more importantly, businesses, commercial enterprises around the world took full advantage of the convention and the model law. Businesses of all sorts in every economic sector in every part of the world included arbitration agreements in their contracts, agreements providing for the resolution of future disputes by some form of international arbitration. Institutional arbitrations have, in absolute numbers, increased 6 or 7-fold over the last 30 years, taking full advantage of the New York Convention. The case statistics at different arbitral institutions have shown very substantial increases. The Singapore International Arbitration Center, where I have the privilege, the honor of being president of the Court of Arbitration, has gone from 2 cases or so in the early 1990s to this year, what will be pushing 1,000 cases filed per year. Other arbitral institutions have shown similar growth. ICSID, the International Center for the Settlement of Investment Disputes, has seen its caseload rise from barely a handful of cases in the 1960s and 1970s to well more than 100 cases in some recent years, and predicted, I'm told, for this year as well. Providing the ICSID Convention, the Washington Convention, providing a global constitution for investor state arbitration just the way the New York Convention does for international commercial arbitration. International arbitration wasn't known just for the quantity of the disputes that it resolved, but also for the diversity of disputes that it resolved. Disputes not just in Europe or between North America and Europe, but disputes all over the world, in Asia, in Latin America, trade between the Middle East and Asia, North America, disputes of every sort involving parties from every geographical region, every legal system in the world. Different industries traditionally like sale of goods, manufacturing industries used arbitration, but increasingly in the past 3 or 4 decades, arbitration has been used to resolve other categories of disputes which historically were not subject to arbitration: intellectual property disputes, financial disputes, sports disputes, investor-state disputes. In all these areas, international arbitration was embraced robustly by nations around the world. Keep in mind the 165 contracting states to the New York Convention and the 150 or so contracting parties to the ICSID Convention. And by private businesses who, as I said, have used increasingly international arbitration to resolve their disputes. In many ways, it looked not just like a springtime for international arbitration, both commercial arbitration and investor-state arbitration, but indeed a full-blown summer. Clouds appeared on the horizon, though, in the last decade or so. Those clouds took a variety of forms, and they arose first in the field of investor-state arbitration, where first with the so-called Osgood Declaration, a handful of law professors criticized the investor-state arbitration process, arguing that it lacked transparency, that it lacked objectivity and neutrality, that it didn't produce sufficiently consistent results. They argued ultimately that it undermined rather than advanced the rule of law. States around the world, including states in Latin America, Venezuela, and others, criticized investor-state arbitration, renounced their bilateral investment treaties, withdrew from the ICSID Convention. Other states, including the United States, rethought their bilateral investment treaties and revoked the promises that they had made to investors around the world. Those same types of criticism spread as well to international commercial arbitration, where the arbitral process was again characterized by many as having only an attenuated realization of the rule of law. In some circumstances, as Lord Thomas in this country, in the United Kingdom, argued, undermining the rule of law by depriving national courts of the opportunity to both resolve commercial disputes and to make law for future litigants. Those criticisms deserve to be taken seriously. Do they mean, as some have suggested, that winter might be coming after this summer that we've seen in international commercial and investor-state arbitration? Or are they wrong-headed criticisms, ones that should be discarded so that we can go back to the business of resolving disputes fairly? In my view, winter isn't coming. In my view, summer is coming for international arbitration, both commercial arbitration and investor-state arbitration. And it's doing that for 2 broad sets of reasons. First, arbitration speaks to a fundamental human need, a fundamental requirement of all societies, in particular, all free and democratic societies. Arbitration, at the end of the day, is a creature of the parties. It's a creature of consent. Arbitration arises when 2 parties, who virtually all legal systems today give the autonomy to form relationships, to enter into contracts, to enter into marriages, to form associations. When parties who do that, when parties who contract or create associations fall inevitably into dispute, they naturally want means to mend the relationship which has become broken. They want means to resolve their disputes, just as they wanted means to enter into relationships for their mutual benefit in the first instance. And arbitration is the means that people choose to resolve their relationships, a means tailored to their own positions, to their own particular interests. And arbitration in that sense realizes one of the most fundamental aspirations of the rule of law. It gives effect to the party's freedom, the party's autonomy, not just to contract, but to mend their contracts when they become broken. And it's in all of our interests. Most importantly, it's in the interest of the rule of law that those promises on how to mend one's relationship get given effect, and that arbitral awards mending relationships equally be given effect. And that's one fundamental reason that those who criticize international arbitration as not effectuating the rule of law or undermining the rule of law are wrong. Arbitration gives effect to the rule of law, a basic civil right, in the most fundamental way possible. But in addition, for a constellation of other reasons, which I'll refer to in shorthand as the 6 E's, arbitration also effectuates the rule of law in other ways. Arbitration effectuates the rule of law because, firstly, it's more efficient, and secondly, more expeditious, more expert, more even-handed, more enforceable, and then sixth, more electronic. And I'll explain that in a moment, than the available alternatives. Those 6 E's all apply to any form of arbitration, and thus advance the rule of law. But they apply with particular force to international arbitration. In each case, international arbitration advances the rule of law, realizes the aspirations of parties who want justice better than the available alternatives, national courts or international courts. And let's look at why that is so. International arbitration is more expert than the alternatives, national courts, because the parties have the freedom to choose the arbitral tribunal, typically after their dispute has arisen. After the parties' dispute arises, the parties, whether they're parties to an insurance policy, a construction contract, or the infrastructure project to build a telecommunications network, the parties in each one of those cases are free, and almost always do, appoint tribunals specialized and expert in that subject matter. In insurance cases, parties appoint insurance experts. In construction cases, parties appoint construction experts. In joint venture cases to build a telecommunications network, parties appoint arbitrators skilled in those particular disciplines. Likewise, parties are able to choose arbitrators that are qualified in the relevant laws, who speak the relevant languages. And all of that, these choices are made by the parties themselves, who have the most knowledge about what their dispute concerns, what disciplines, what abilities will be necessary to efficiently and effectively and fairly resolve it. The parties have the best knowledge of anyone in the world, and they have the greatest incentive to ensure that the tribunal is properly chosen and the best possible tribunal to resolve their dispute. That contrasts dramatically with national courts, who choose judges arbitrarily and randomly, a little bit like a coin flip, choosing judges who are not specialized in particular disciplines, but who instead must necessarily decide every kind of dispute, from tax disputes to environmental disputes, landlord-tenant disputes to consumer disputes, and perhaps occasionally the insurance or the construction disputes that the parties actually present to the decision maker. And for all those reasons, international arbitration is more expert than the alternatives, and thus better effectuates the rule of law by providing a more informed, more expert, a better decision than the available alternatives. And that's one of the reasons that parties, commercial parties, who are informed, overwhelmingly prefer international arbitration to the alternative. The second E that I'd like to talk about is even-handedness. The parties choose international arbitration because it's more even-handed, because it's more neutral and thus more objective, less biased, less parochial than the available alternatives of national courts. Parties are free to choose their own co-arbitrators, the party-nominated arbitrators, but they will agree upon a neutral presiding arbitrator. Often they'll seat their arbitration in a neutral venue. If the parties are unable to agree upon the identity of a presiding arbitrator, they often are able to agree, in which case one has a uniquely even-handed tribunal. But if parties cannot, then an expert arbitral institution will choose a presiding arbitrator. The basic rule for choosing a presiding arbitrator is that she or he will be of a neutral nationality, not the same nationality as either of the parties. And thus, one has to compare that process, which produces a uniquely even-handed decision maker, with the process that would otherwise obtain in national courts, where each party sues in its own home jurisdiction, guaranteeing itself a home court advantage. Neither party, of course, wants to be in the other party's home turf, and thus very frequently one gets parallel proceedings. But those parallel proceedings are each in a national court of each party's respective home jurisdiction. And that's not even-handed. It's two uneven playing fields, two playing fields that aren't level. And again, when you ask yourself, which has the more direct, which has the better effectuation of the rule of law, it is national courts that produce an attenuated, defective means of dispute resolution in that case. Two other E's that we can touch on briefly, which arise from some of the characteristics of arbitration that we've already discussed. And they are that arbitration is more efficient and more expeditious than the alternatives. Arbitration is more expeditious and therefore more efficient because the parties are free to design the arbitral procedures to suit their own particular circumstances, their own particular dispute. If one wants things like witness conferencing or a site inspection, unlike national court judges, arbitrators aren't bound by ancient rules of civil procedure. They're not bound by national borders with respect to site inspections. They also, in most cases, don't benefit from the procedural innovations that have occurred over the last 15 years or so, in which most arbitral institutions have introduced things like expedited procedure or early dismissal. The ICC rules, the SIC rules, many other institutional rules provide fast-track mechanisms for resolving smaller value or less complicated disputes, producing awards which are final and binding in a period of less than 6 months. Importantly as well, the arbitral awards under the UNCITRAL model law and other national arbitration legislation are not subject to endless rounds of appeal, multiple levels of appeal, which often end up putting the parties back in a new trial court after several years or several decades, as the country may be, to start the process again. Justice denied, they often say, is justice delayed, they often say is justice denied. When national courts delay justice the way they do in comparison to international arbitration, it's in a very real way, justice denied. Arbitration is also more enforceable as compared to national court decisions. That's because of those conventions that we talked about previously, the New York Convention, the ICSID Convention, which obligate contracting states to recognize and enforce arbitral awards, subject to only very limited exceptions for jurisdiction, public policy, and gross procedural irregularities. There's no right of appeal in international arbitration, and therefore no obligation to go through endless rounds of additional legal briefing and reconsideration of a decision that's already been made by an expert tribunal. Necessarily, that means the arbitral process is substantially quicker than the alternatives in national courts. It's also substantially more certain to produce a result that will be recognized in other jurisdictions. National court judgments are subject to no international convention like the New York Convention, like the ICSID Convention. As a consequence, a national court judgment doesn't really resolve the parties' dispute in the way that the parties want. A national court judgment simply begins a new chapter in the parties' dispute. A a chapter that's devoted to denying recognition of the national court judgment. In contrast, international arbitral awards are voluntarily complied with in more than 90% of all cases. And where they're not voluntarily complied with, the convention provides ready means to enforce them. My final E, the final reason that international arbitration doesn't have an attenuated connection or realization of the rule of law, but instead realizes it better, substantially better than the alternatives, is a new E. It's that international arbitration is more electronic in these pandemic days. One would have thought that if one can't conduct in-person hearings anymore, if counsel can't travel from around the world to confer with their clients, to present their cases before an arbitral tribunal, if arbitral tribunals couldn't come together and deliberate on how an award should be drafted, how a case should be decided, that the arbitral process would come to a halt, the way that many national courts have come to a halt, or at least drastically curtailed their ordinary operations. The opposite's been true in international commercial arbitration. At the Singapore International Arbitration Center, our caseload is nearly double what it was this time last year. Other arbitral institutions, ICSID and others, report significantly increased case filings. It's not that the arbitral process is less available during the pandemic. In many ways, it's become more available. Just as we're all able today from all the continents of the globe, as Jose Gregorio said, to participate in this webinar, so parties conduct virtual or remote hearings. The arbitral process has gone forward not just with increased case filings, but also increased access to hearings. Parties who frequently in the past would have had to spend lots of time and money traveling to some geographical location now, in a sense, better realize the ultimate ideal of international arbitration. They have truly international hearings conducted remotely. And technology has enabled those hearings to go forward just as effectively as in-person hearings. There are, of course, unique circumstances, exceptional circumstances where that may not be possible, either because of deficiencies in internet access, because of insuperable obstacles with time zones. But in virtually all cases, that isn't true. In virtually all cases, arbitral tribunals have found a way using technology to permit, notwithstanding the pandemic, the arbitral process to go forward, including through the conduct of hearings and the making of final awards. And all of that makes me think that it's not winter that's coming, it's summer that's coming. Again, international arbitration has demonstrated that it is more flexible, better able to accommodate the parties' aspirations for having their disputes resolved in accordance with the rule of law, better able to deliver in accordance with the 6 E's, results in accordance with the rule of law. That's the challenge that we all have to meet, to live up to those aspirations, to ensure that summer really is coming for international arbitration. But I'm confident that together we can do that. And thank you for an opportunity to speak with you this morning, this afternoon.
Thank you very much, Professor Bourne. We are going to start with the questions. The first one is by Saadia Bhatti. Aren't the current discussions at UNCITRAL Working Group 3 reform of ISDS, in particular with the creation of multilateral investment court, with a possibility to appeal decisions put into question several of the ES, efficiency, expediency, enforceability, and even-handedness?
I do think that some of the critiques that inspired the UNCITRAL Working Group to begin to study these proposals reflected disagreement with respect to all 6 E's. I think there have been complaints about aspects, in particular in investor-state arbitration, of the even-handedness of tribunals. And there have been critiques, again, principally in the investor-state field, with respect to the efficiency and expedition of the arbitral process. I think that those critiques were fundamentally wrong. And I think that the reaction of many states to those critiques underscores that. I think with respect to even-handedness, if you look at the track record in investor state cases, particularly ICSID arbitrations, the experience is not at all that there was a lack of even-handedness. On the contrary, there was, I think, a demonstrable neutrality and objectivity in investor state arbitration decision-making. Professor Susan Frank has done a very thorough empirical study with respect to the results in ICSID arbitrations. The study concludes in very broad and somewhat simplistic terms that you can divide the decisions in investor state arbitrations into 3/3, if I can put it that way, each reflecting roughly 30% of the total number of investor state arbitrations. In 1/3 of all those cases, states prevailed entirely. In another third of all those cases, investors prevailed, but almost always only partially. And in the final third of all those cases, the parties mutually resolved their dispute through a settlement after the arbitration had been initiated. In my view, that's not at all the track record of a decision-making process that lacks even-handedness. On the contrary, it is precisely a track record of a process that is producing balanced and fair results. I think particularly notable is the 1/3 of all disputes being resolved amicably by settlement. I think that's a sterling achievement, and it testifies to the fairness of the investor state arbitral process. I think when one is honest about the European Union's proposal for an investment court and similar discussions to that effect in UNCITRAL working group, it is anything but even-handed. The process for choosing arbitrators in investor state arbitration, like in other arbitrations, is a quintessentially even-handed process. Each party, the host state on one hand, the foreign investor on the other hand, chooses one arbitrator, and that's even-handed. The two parties together agree upon a presiding arbitrator. If they can, that again is quintessentially even-handed. If they can't, an independent arbitral institution chooses a neutral arbitrator without the nationality of either party after a thorough conflicts check. That too is quintessentially even-handed. The proposal of the critics of ISDS is to replace that with a court chosen entirely by one set of parties, namely host states. That would be bad enough if this were just a general court responsible for resolving all types of disputes between states, a little bit like the International Court of Justice. But the European Union wants to do something different, and in my view, much more pernicious. They want unilaterally to choose all of the judges to resolve one category, one relatively narrow category of disputes, investor state disputes. That is reminiscent of the Star Chamber in medieval England, where the king would choose all of those who would decide on the freedom of his and the lives of his enemies. That isn't even-handed, and it's not meant to be even-handed when you think about it. What the critics really aspire to here is ensuring that the dispute resolution process is not even-handed.
Would you say, Professor Bourne, that there is not really a legitimacy crisis, but a reaction from the states, basically because of the increasing accountability brought by the investment arbitration?
I would say that. I would say it's not a legitimacy crisis. It's in a sense, a sour grapes crisis. What is really at stake is states wanting not to be accountable. And if you look at who have been the principal proponents, the principal of those changes, the principal critics of ISDS, from Donald Trump to Vladimir Putin to Hugo Chavez, I think one can see the reality of that observation.
Thank you, Professor Bourne. Our second question is from Isham Das. He has given the advantage of having experts as arbitrators. Can arbitration be used to tackle issues like climate change and human rights, for example, in supply chains? If so, will the issue of public policy be a hurdle?
That's an excellent question, and I think it's one that deserves further thought and further discussion. Um, Arbitration has been used in a variety of areas like those, climate change, human rights, and used to some extent successfully in these areas. I think in particular of arbitration being used, the Court of Arbitration for Sport being used to resolve very difficult issues, often involving questions of personal dignity, of quasi-criminal conduct, and it's been used successfully there. Arbitration has been used successfully in the context of corruption. Arbitral tribunals have, in some sense, been ahead of national courts in identifying corruption in commercial dealings and drawing the appropriate legal consequences from that. One can think of that both in investor-state arbitration, but also in international commercial arbitration. The Transparency International, one of the leading NGOs in the field of anti-corruption efforts, included arbitration clauses in its integrity, anti-corruption pledges that were to be used by municipalities, used by state agencies in letting public contracts where corruption can be a particular problem. And I think, therefore, that arbitration has real promise to be used in areas like climate change, like human rights. I think in particular, in the field of human rights, if states were to actively embrace the possibility of having human rights claims resolved through arbitration as opposed to through other mechanisms, there's real promise for that possibility.
Excellent. Our next question is from Wolfram Bogwich. I perfectly agree with you that international arbitration is a result of allowing parties to freely enter into contracts, comprising contracts on how to resolve their disputes. Yet, there are many states in the world today that do not respect individual freedom as much as we do in Western societies. Do you nevertheless think that international arbitration will have a spring time in the future?
I do. I think that obviously there are significant differences around the world in political systems and different ways of hearing the voices of the people. No single nation has a perfect recipe for how those ideals can be realized. In the field of commercial activities, though, for the most part, states have come to recognize over the past 30 years that private parties, private enterprise, play a leading and essential role in commercial activities. And that's been true in most jurisdictions around the world. Obviously, there are different approaches in different countries to that, and some countries don't always adhere to that consensus, often, though, as a consequence, realizing serious economic pain as a result. Because of that, because of the central role of private parties in commercial activities, most states have, and my both expectation and hope is that most states will continue to recognize the critical importance of arbitration in resolving commercial disputes. That is especially true in international commercial affairs, where parties don't just have the question of, aren't just presented with the question of, isn't it best to leave the resolution of commercial disputes to commercial parties and the tribunals that they choose, but also the added difficulty of what nation is permitted to resolve commercial disputes, what court could resolve this, and how would it make its decision enforceable outside of its own borders. international arbitration through the New York Convention and the ICSID Convention have stepped up to that challenge and provided an effective means of international commercial dispute resolution, which at the end of the day, virtually all states, whatever their political complexion, want to see realized. And as a consequence, I continue to think that spring, indeed summer, is coming for international commercial arbitration.
Our next question is from one of the Venezuelan members of the association of the AVA, Asael Socorro. In your opinion, how feasible in the future is the implementation of artificial intelligence robot arbitrator as a substitute for a human arbitrator?
I'm going to ask my computer to answer that. But while it's trying to process the answer, let me say that I think it is probably a very long way before artificial intelligence is going to replace human intelligence in resolving disputes, whether domestic or international. The difficulty with letting an algorithm resolve your dispute is one always wants to know who wrote the algorithm and what the algorithm really says. I'm highly skeptical that sophisticated commercial parties will, even if an algorithm that could reliably resolve parties' disputes, produce something intelligible in particular circumstances existed, that they would be willing to give up their role in the arbitral process, including selecting the arbitrators and presenting their cases to essentially machines.
Thank you, Professor Bourne. The turn is for Pedro Rengel. He asked, appeal against arbitral awards has recently been included as an option of the parties in some rules of International Arbitration Center and in some jurisdictions. Would you see a tendency of parties opting for such alternative, or it is rather seldom used?
My experience, for what it's worth, first of all, I agree with the premise of the question. One has seen, especially in the last 5 or 10 years, arbitral institutions instituting changes to their rules, which allow parties the possibility of opting into some sort of appeal mechanism. My own personal experience is that this is used quite infrequently, and in my discussions, both in Europe, but also in Asia and the United States, commercial parties are quite skeptical about the value of such a mechanism. I think that it needs to be seen in the context of the first E that we discussed, the expertise of the arbitral tribunal. When parties can choose the tribunal after a dispute has arisen, when parties themselves are directly involved in the selection of the arbitral tribunal, when an expert arbitral institution chooses the arbitrators based on its institutional knowledge and experience, if the parties can't agree, one gets a tribunal where, if I can put it bluntly, you're less likely to get serious mistakes the way that you are likely to get them if you have a sole national court judge chosen randomly without particular experience in the field. You need appeals there because you've created a recipe for mistakes. You have less risk of that in a 3-person tribunal chosen after the fact by parties with intimate knowledge of the case and an incentive to have an expert decision maker. I think, in addition, commercial parties are skeptical about the value of an appeal, even if one accepts that a first instance decision will, in some circumstances, be mistaken, make the wrong decision. One has to also have confidence that a second instance decision will instead reach the right decision instead of perhaps a new wrong decision in a sufficient number of cases to justify the time and expense. I think that if you have a arbitrarily chosen, randomly chosen appellate tribunal, the risk of a new mistake overturning a correct initial result actually is increased. And thus, I think many commercial parties are deeply skeptical about the value of an appellate mechanism. All that said, international arbitration at the end of the day is founded on party autonomy, on consent. If commercial parties want an appellate process, even if that does not make particular sense when you think it through, they will have the freedom under many institutional rules to do so. The fact that they choose not to is important, but it shouldn't deny them the freedom of doing so if that's what, for whatever reason, they wish to.
The next question is posted by Aichel Alvarado. Confidentiality is one of traits of international arbitration processes. Do you believe if cases are too confidential, may perhaps be a disadvantage instead?
I think it's a thoughtful question, and let me first, if I can, challenge the premise just a little bit. The premise is that confidentiality is a trait or essential characteristic of international arbitration, and that's not entirely true. I think the more accurate way to put it is that party autonomy in deciding whether an arbitration is confidential or not is a fundamental characteristic of international arbitration. In some cases, parties want confidentiality. As the question suggests, that's undeniably true. In a number of cases, though, parties in particular commercial sectors don't want confidentiality. And their maritime sector, other sectors in particular countries, arbitrations, arbitral awards are not confidential, and in fact are circulated widely among particular economic sectors, participants in particular economic sectors, depending upon the needs of that commercial sector. Also, different countries take different approaches to questions of implied confidentiality in international arbitration. Some jurisdictions, United Kingdom, Singapore are good examples, have a very strong obligation of implied confidentiality. Other jurisdictions are different and don't recognize such an obligation, leaving the parties free to publicize the arbitration and also the arbitral award. And thus, although one often hears it said that confidentiality is an attribute of or an essential characteristic of international arbitration, that's not entirely true. In fact, like other aspects of the arbitral process, it's a more diverse and a more varied picture. And I think commercial parties should think hard, should consider hard, whether in fact, in particular contractual relationships, in particular circumstances, confidentiality is something they want or something that they don't want. I do think in general, the move of arbitral institutions over the past 15 years or so towards more ready publication of redacted awards is a good trend. I think that it makes available the availability of redacted awards that don't identify the commercial parties to the dispute, makes available to the wider commercial public, to the arbitral community, the hard work of previous sets of counsel and arbitrators, and provides guidance in comparable circumstances in the future. And in that way, I think the arbitral process, if awards are made more freely available, will be advanced. I should say, just finally in conclusion, that a substantial number of commercial awards already make their way into the public domain. And of course, as we all know, most investment arbitration awards make their way into the public domain, either because relevant institutional rules provide for transparency, not confidentiality, or because in recognition, enforcement, or other proceedings, the awards are made public.
Thank you. The next question, and we have time for just a few more. Ruben Villavicencio asks, in sports law, arbitration is a great success to settle controversies. He considered that it is a great option to be able to resolve commercial situations simply and with greater speed than by ordinary means, even more so in the conditions of Venezuela and its justice system. My question is, how does compliance with awards affect Venezuela, in special if special courts are required to comply with those decisions when one of the parties does not do so voluntarily? Which way does it suggest?
So I agree entirely with the question's observations with the use of arbitration in sports disputes. I think the Court of Arbitration for Sport in Lausanne, Switzerland, has done a spectacular job in the field. I think some of us forget when we watch the Olympics that the CAS, the Court of Arbitration for Sport, is really essential for the efficient conduct of the Olympics. Its tribunals are able to make decisions in some cases a matter of hours, where huge stakes are at play. And I think the use of expedited procedures in commercial arbitrations has in some ways learned from that in a way that hasn't been commented on that extensively. But the ability of sports arbitrations to act in a fast track manner, I think, had an influence on both emergency arbitration, but also expedited procedures. Today, with emergency arbitration, emergency arbitrators are appointed sometimes even before a request for arbitration is filed, certainly after it's been filed, and often make interim awards, interim orders in the space of literally hours, sometimes days. And those can be essential in both preserving status quo in particular disputes, but also in ultimately resolving the parties' dispute in a fair and equitable manner. Obviously, issues of recognition are important. Voluntarily compliance is quite substantial with arbitral awards, but in part that's because parties act in the shadow of the law. They comply in part because they know that if they don't, they will ultimately be forced to comply. And insofar as particular jurisdictions refuse to recognize arbitral awards, that promise is undercut. One of the true reasons for success of the New York Convention, though, is because it is global, and because an award creditor, a party that obtains an award, needn't only go to the award debtor's home jurisdiction, but can go to 165 jurisdictions around the world to seek to recognize and enforce that award. It's very hard to run and hide when the only place you can go is North Korea, which is not a party to the New York Convention. And thus, although some countries have done less well than they should, most countries, in fact, have done really quite well in recognizing and enforcing foreign arbitral awards. And where they haven't, other countries have, if I can put it this way, picked up the slack.
Thank you, Professor Bourne. Next question. In line with the question of Asael Socorro, do you know any case where artificial intelligence has written the arbitral award? The question is posted by Lucia Grandinetti.
My answers thus far have been long. This one's short, no.
Great. Mr. Adolfo Baica asks, I understand that arbitration is occupying larger spaces in the solution of controversies in the world. Do you think that the costs and fees of arbitrators should be reduced?
That's a good question. It's one that's often on the minds of commercial parties. Commercial parties, both in the times of the pandemic and otherwise, obviously always strive for maximum efficiency in everything they do. That includes in arbitration. My own view is that although it's important to structure carefully the fee arrangements for arbitrators, those fees, arbitrators' fees, institutional fees, are really the smaller, decidedly the smaller part of the overall costs in international arbitration, dispute resolution generally. The predominant costs are, of course, the costs to the parties' respective counsel. Lawyers' fees are 10 times at least that of the arbitral tribunal, sometimes many more in most cases. And therefore, that's, in my view, the principal focus of efforts to ensure the efficiency and cost effectiveness of international arbitration. I also think that the time that parties themselves spend, as well as the fees that they pay to their outside counsel, is very important. Distraction in terms of management time, the cost of in-house legal counsel are also significant costs that need to be taken into account. In my view, the most important way to take those into account is to ensure the efficiency of the arbitral process. Dispute resolution is a little bit like Uber or taxi cabs. You pay by the hour in most cases, and the more time it takes to resolve a dispute, the more it's going to cost, both in internal time and outside counsel time. As a consequence, I think fee arrangements that give the arbitral tribunal a strong incentive to resolve the dispute in an efficient way rather than an inefficient way are critical. That doesn't mean paying the tribunal less. It means paying the tribunal smarter. It means paying the tribunal for producing a result within an expeditious time frame, not within a long drawn out time frame, because in doing that, you ensure that the lion's share of the party's real costs is contained. I also worry to some extent that one cannot too much limit the fees paid to the arbitral tribunal in particular, because at some point it begins to degrade quality. One needs to ensure that the tribunal has the appropriate incentive to pay complete attention to the party's submissions and to prepare an award that really sets out carefully and thoughtfully the tribunal's decision.
Thank you, Professor Bourne. The next question is asked by Maria Inés Corrá, who is a member of the board of directors of the Latin American Arbitration Association, ALARP. Our greetings to Maria Inés. She asks, to the best of your knowledge, to what extent the court's interference to arbitration may jeopardize the effectiveness and general advantages of arbitration? And what do you suggest that it could be done by institutions, centers, international organizations, etc., in order to tackle this issue?
That's a good question. And I fully agree that judicial interference in the arbitral process could, if prevalent or widespread, undermine the arbitral process, negate many of the 6 E's that we talked about previously. Fortunately, most countries' courts have not done that. Most countries' courts have adopted a rule of what I call judicial non-interference in the arbitral process. The UNCITRAL model law on international commercial arbitration in Article 5 has an express requirement of that. Courts are not permitted to intervene in the arbitral process except where provided for by the model law, and those provisions for court involvement in the arbitral process are extremely limited. They're limited to constitution of the tribunal if the parties haven't agreed otherwise, to resolution of interlocutory jurisdictional challenges, very limited possibility there, and finally to annulment of the ultimate arbitral award, but only on very limited grounds. Most countries' courts have that apply the model law have given full effect to Article 5, and in non-model law jurisdictions, United States, for example, courts have recognized a generalized obligation of judicial non-interference. Under the New York Convention, the same requirement arises out of Article 2 of the Convention. And again, most countries' courts have honored that obligation quite well. I do think the question underscores a broader observation about the importance of the public-private cooperation in international arbitration. International arbitration is not some detached international process that has nothing to do with national law or national courts. Instead, international arbitration flourishes. It's going to be summer because of the partnership between international businesses on the one hand, national legislatures, national courts on the other, both working together for their mutual long-term benefit. It's in everybody's best interest. And thus far, national courts over the last, since 1958, when the New York Convention was drafted in New York, national courts, national legislatures have, for the most part, upheld that commitment. If summer's going to come, though, it will require for national courts and national legislatures to continue to do so, and continue to do so in a wholehearted and committed fashion. I believe, because it's in the interests of states, it's the interest of business, that they will continue to do so. But should they not, then international arbitration as well as international trade itself will be threatened.
Thank you, Professor Bourne. We have more or less 3 more questions. If you have the time, I would like to read them all.
Why not?
Perfect. Rashmita Roy Chowdhury asks, given the new way of virtual hearings in arbitration, is there a possibility that arbitrators might find it less engaging considering the hearings are conducted virtually and not in person? Furthermore, could that prejudice the parties in any way?
It's a good question. It goes to my 6th E, that arbitration is more electronic than the alternatives, and thus better able to cope with the present pandemic, and after the pandemic ultimately goes away, better able to provide efficient dispute resolution in the future. I think the answer to the first part of the question, do you pay more attention or less attention in a Zoom hearing than an in-person hearing? Depends a little bit on how you're reacting to me. Are you paying attention to me in this Zoom, or would you pay more attention if I were at the other end of a big auditorium? Ask yourself that question also if you've just flown in on a plane from halfway around the world and are struggling with jet lag, and if, as some arbitrators are, you're not 35 years, but 75 years old. I think that in some ways, Zoom hearings actually enable people to pay more attention. We've all read, obviously, about Zoom fatigue and the like, and sometimes as I sit here alone in this room and stare into the little white dot on my computer, I wonder if anybody's really listening. But I think experience teaches that people do listen, people do pay attention, and that we all need to adjust to changes in technology, but remote hearings offer very real savings in time and money, and for that reason will probably become the wave of the future.
Excellent. The next question is posted by Alicia Largazabal, one of our dear members of the international chapter of AVA. She asks, what role do you believe arbitrators should play in the development of the rule of law? For instance, COVID-19 has disrupted numerous contracts and many issues of hardship and force majeure have arisen. Do you think arbitrators may have the power to adapt contracts in certain cases, despite there is scare case law, arbitral awards, judgments that allow this possibility?
It's a good question. It's a challenging question. Um, I think first, arbitrators do play a very important role in upholding the rule of law and in developing the rule of law. For all the reasons that I outlined previously, I think arbitrators, international arbitrators, do a better job in international disputes in upholding the rule of law than national courts do. The freedom of arbitrators to apply the law, the rule of law, is, according to one view, substantial. Annulment proceedings don't involve substantive review of the merits of the arbitrator's decision. The national court, under Article 35 of the model law, Article 34 of the model law, in annulment cases doesn't re-examine the substance of the party's dispute. So in one sense, arbitrators have substantial discretion. On the other hand, arbitrators are mandated to apply the law. Article 28 of the UNCITRAL model law requires them to apply the law chosen by the parties or that they determine to be applicable. Arbitrators are not free. Article 28 also says to act ex aequo et bono, and if they do, they violate their mandate. I think that one of the beauties of arbitration, one of the reasons that international arbitration is so popular, is that different tribunals react to different situations, depending on what the relevant rules of law are, depending on what the underlying factual circumstances are in different ways. Often arbitrators are called upon to apply archaic rules that may never have been conceived to apply in circumstances like the pandemic. In other cases, they may apply quite modern rules that perhaps were drafted with things like the pandemic in mind. Arbitrators have both the experience and the flexibility, I believe, to modulate their response, to adopt nuanced responses depending upon the circumstances of individual cases and what it is that actual applicable law really does or doesn't provide.
Thank you. The next question is asked by Jose Alberto Ramirez, who is the acting executive director of ABA. The Venezuelan arbitration community is currently facing a case under which the Constitutional Chamber of the Supreme Tribunal of Justice recently issued an interim decision allowing a very special and limited remedy called avocamiento to be a procedure for ordering the referral to the chamber of one pending arbitral case being processed by one of the main arbitral institutions, SEDCA, and the temporary suspension of the arbitration procedure pending a decision from the chamber. This is an outrageous judicial intervention and a violation to the Venezuelan arbitration law and case law. If this wrongful judicial criteria ends up materializing, would you say this precedent could constitute sufficient basis for future allegations of inconvenient arbitral situs as sufficient grounds for challenging the validity of an arbitration agreement that provides Venezuela as the seat?
It's a few reactions. Firstly, that does seem, as you describe it, like a fairly flagrant violation of Article 5 of the UNCITRAL model law, the approach of judicial non-intervention that I referred to a few questions ago. The overwhelming consensus of both legislatures and courts around the world is that courts should not, may not intervene in the arbitral process until it has concluded. And that's a wise rule. It's one that the New York Convention, if this is an international arbitration, guarantees and imposes obligations on Venezuela as well as on other contracting states. I think that if that were done in this particular case in a way that appeared to make law, to state what Venezuelan law was, then parties who had seated their arbitration in Venezuela prior to that decision, in reliance on Venezuela's previous adherence to the rule of judicial non-intervention, would have a quite serious argument that the arbitration agreement, or at least that portion of it selecting Venezuela as the seat of the arbitration, should be re-examined under the doctrine of changed circumstances. The rule against judicial non-intervention is a fundamental provision of international arbitration law, national arbitration law in most countries. And a 180-degree reversal of the position on that, I think, would raise very serious questions as to whether the arbitration agreement, or at least the selection of Venezuela as the seat, would remain valid. Many countries' courts try, I think quite rightly, to uphold so-called pathological arbitration agreements, even if there's a defective term or an invalid term in the arbitration agreement, you still try to give effect to the agreement to arbitrate. In the circumstances we're talking about right now, I think a very plausible outcome would be that agreement on Venezuela as the arbitral seat would be held invalid on the basis of changed circumstances, frustration, something along those lines, but that the underlying agreement to arbitrate in a different arbitral seat would remain in effect.
Thank you. The next question is by Saadia Bhatti. Thanks for your presentation and for answering questions. Fully agreed. The solutions to the so-called problems to ISDS currently suggested by states, and in particular the European Union, seems instead to create new problems, particularly with proposing an appellate court and creating a permanent court with adjudicators chosen by states only. I would say spring may be coming for international commercial arbitration, but not so sure when we will be through the snowstorm affecting the world of investment arbitration. She puts a smiley face.
It's appropriate that Saadi asked the first question and also the last question. I think there's force to the metaphor that we've got a bit of a snowstorm for ISDS, investor state arbitration. The revisions to NAFTA are one tangible example of that snowstorm. The ACMEA decision and the EU treaty terminating intra-EU bilateral investment treaties is another manifestation. That said, one needs to look at the longer arc of history. And I remain confident, I remain certainly hopeful, even if sometimes confidence might wane, that humankind will in the end do the right thing, that the benefits of investor state arbitration, the contributions that it has made over the past decades to the enormous reduction in poverty around the world, the enormous prosperity that some parts of the world have come to enjoy, will lead states ultimately to not just do the right thing, but also to do the good thing. And by that, I mean, not just to resolve disputes in a way that advances international trade and investment, but also that resolves disputes, including disputes involving those own states' conduct in a way that's fair and even-handed. It is ironic, I must say, that the European Union when finally the day comes that European states are not the homes of claimants, but instead European states are the respondents, decide that it's time to change the investor state system and to withdraw the protections that they promised to foreign investors. That's not the way that a country, a body that is committed to the rule of law would behave. And I think ultimately history will judge them, judge the critics of the ISDS system very harshly.
Thank you, Professor Bourne. Our last question is asked by Hernan Oriolo from Argentina. Could you comment on any progress related to treaties in which states would have set forth that any controversy must be arbitrated unless otherwise agreed by the parties? Thank you.
The variety of treaty arrangements that sort of follow those general lines. I think in broad terms of bilateral investment treaties themselves, many of those treaties have so-called standing offers to arbitrate by host states that allow foreign investors to either choose to accept or choose not to accept the state's offer to participate in an investor state arbitration. In a sense that is similar to what the question asks. The host state promises to arbitrate unless the foreign investor chooses not to. In a sense, commercial arbitration agreements also meet that paradigm in the sense that parties are always free to waive their rights to arbitrate and to instead litigate their dispute. Parties don't do that very frequently, but they're certainly free to do so. There was in the early part of the 20th century a series of bilateral arbitration treaties between different countries where they agreed to resolve certain types of disputes by arbitration, boundary disputes, that sort of thing. Those treaties, unfortunately, have fallen into disuse, in part, I think, because of a desire for a more global system of international dispute resolution. First, the Permanent Court of International Justice, then the International Court of Justice. I wonder if perhaps the time isn't right to think about bilateral arbitration treaties between states as a means of resolving disputes in a more piecemeal fashion that nonetheless might produce more effective results than what we see currently today.
Thank you very much, Professor Bourne. With this final comments of what I think was a fantastic event and a deeply interesting lecture by Professor Bourne, I would like to thank again to all those who connected to this webinar, and of course, in the name of the Board of Directors of ABA, express our thanks to Professor Gary Bourne for sharing his ideas with us today. Professor Bourne, would you like to make a final remark? Any last comment?
Only to thank you and all the participants for both the attention and also the very interesting, very stimulating questions. It's been both a pleasure and an honor. Thank you.
Thank you very much. Well, please follow us in our social network accounts in LinkedIn, Twitter, Instagram, Facebook, and subscribe to our channel in YouTube, where you will be able to listen or to watch again all of the webinars we have been hosting during this year, including this one. Again, thank you very much for joining us today, and hope to see you again soon.
Thank you all.
Thank you.